The matter of the parentage of DD, a minor child by and through his next friend and father, Daniel Allen Dester II, petitioner, Mackenzie Martin, respondent, case number 2023 DM 409. Beginning with petitioner, would counsel announce appearances for the record, please?
Yes, thank you, Your Honor. Daniel Allen Dester II appears by and through counsel, Mindy Ellen Wheeler, both appearing by Zoom.
Respondent Mackenzie Martin appears by and through counsel, David Morgan, and she's also here in my office today participating in this hearing.
Counsel, are there any agreements that have been reached regarding the issues raised by the motion?
Well, Your Honor, I'll start. It appears we're very, very close, but we had prior orders and a judgment. We were very close. We never got them finalized. Some new things happened, and then we filed this motion to terminate father's time. We have received some information recently, and we haven't been able to agree on all terms. I guess I need to ask Ms. Wheeler if our final terms were acceptable.
Without going into too much detail based on those terms, I'll tell you that the second option you gave me, my client does not agree with, but would agree with the counter proposal I made to you.
Okay. Then we don't have an agreement, Your Honor.
Okay. All right. I was interested in the word you used earlier, Mr. Morgan. You're going to terminate the father's parenting time?
No. Well, he hasn't been seeing the child, so what we are asking the court is to terminate his time temporarily.
Or in other words, suspend his time.
Suspend his time. Okay, I'm sorry. Suspend his time, and I would set this for a full hearing where at some time we can come in and address every issue, resolve every issue. If father thinks he is able to see the child first on a supervised basis, he will have his chance to present his case to the court, and the court can rule. But that's what we're asking the court today. Suspend his time.
Okay, just a moment. Isn't there already an agreement in place where he has supervised visitation?
Yes.
Well, if it's supervised by responsible adults, why would there need to be any curtailment of his parenting time at this point?
Because we've had received information that his parents weren't supervising his time at all times. And we hope to see father take the better road. Other things have happened since then where he has shown that he's still drinking, he's being irresponsible. We don't trust that he's being unsupervised, therefore he's caring for the child. We believe it has raised itself to a safety risk, and suspend his time, but give him a hearing where he can come in and prove the things that he needs to prove to have time. Now, if he is not seeing the child now, he has not seen the child since, I think, the 1st of August. If we do go back to supervised, we would like to go in a step-by-step method and start with every other weekend only. The child goes to school, he's used to this schedule. We would recommend that if the court says, well, let's continue with supervised, that he only have every other weekend, and then step it back up to where there might be one day during the week, because the child is accustomed to a school schedule now.
Even though he's only 3?
Yes, he does go to school.
Yes,
Every day.
except for Friday.
Except Friday.
All right. Ms. Wheeler, some concerns have been raised. What is your response to Mr. Morgan's presentation?
Well, my response would be there are no reasons here to terminate or suspend my client's parenting time. Miss Martin or Martine, the mother, actually chose to end the supervised parenting time, making certain informal allegations that haven't been supported by any evidence that I've seen regarding the parents not supervising. My client, in the meantime, was working towards resolving some of the conditions in the prior agreement that we had for supervised visitation and how to move past supervision. Just last week on Monday, a week ago today, he resolved one of the final pieces of that, and all of that information was shared with Mr. Morgan and his client. Or I'm assuming Mr. Morgan shared that with his client. I don't think that there's any reason to delay adopting essentially what Mr. Morgan has included in his proposed or in his exhibits. He proposed he submitted a proposed order that is very much similar to the version that we had agreed to and executed for him. We've since had some discussions. The only thing that seems to be hanging this up at this point in time is if we allow supervised visitation, which I think by the agreement and the prior conditioned order or prior discussed orders, that is what he should be having right now. He was trying to work towards resolving the issues that would satisfy lifting the supervision requirement. We restore the supervised visitation, the same schedule they had before. Our parenting plan states that neither parent should be drinking or using alcohol or before or during their parenting time. I think the big hangup is how long that supervision needs to last. My client's position is that supervised visitation should last until he has satisfied one last piece, which is December 1st. He is scheduled to go back before the Wichita Municipal Court to verify that he has completed the piece of the probation agreement that has to do with getting a drug and alcohol evaluation. And he would be in agreement with keeping the supervision requirement in place to verify that he has completed that requirement. So up through December 1st and verification of completion of that program. And then the provisions for supervision could be lifted pursuant to the pending agreement after that. I could say more, but I think at the very least, what we want to accomplish today is getting his supervised visitation back for sure. And then if the court wants to hear further evidence, formally hear evidence and testimony and see formal evidence on this, then I would hope that we could get it scheduled on or around December 1st. Thank you, Your Honor.
All right, Ms. Wheeler, where would I find this agreement that's been reached by the parties regarding parenting time?
Actually, Mr. Morgan included that in the exhibits that he submitted as his exhibit C is in Charlie. The only difference we've reached since then, Your Honor, is that in paragraph 9, the language would be changed to the child will be transported by a driver with a valid license and properly insured vehicle. But other than that, and the length of time that the supervision requirement would exist, those were the agreements that we reached.
May I speak to that, Your Honor?
You may.
Okay, the court needs to know sort of how this all has come about. And I submitted a notice of another DUI in the end of July and an open container. And that's the information we've had, that he was charged or something. We sent it to them and we get no explanation. Mother knows nothing. I know nothing. We received an explanation on what happened a few days ago today. So this whole time, we don't even know. We think there's another DUI in an open container, and now we find out it was another person driving, and we find out today. But the point of it is, we've been asking about this for a long time. We hear nothing. We found out recently about the probation for the Oklahoma DUI. We just found out about that. So a lot of things. We get pictures of him passed out on the sidewalk, passed out in a bar. All these things mother gets, and it's very alarming to her. And then she says, well, boy, we have all these agreements. We've done all this. These things happen. We ask for explanations. We don't hear anything. We don't hear from him. We don't hear from his parents. And it really is very alarming to mother. So the court needs that backdrop. So now we come forward and say, well, we got an Oklahoma DUI. Well, here he's on probation. Now we proved to you that he was driving with somebody late at night with an open container, but he wasn't the one doing it. So we still think there's enough concern to suspend his time and have a full evidentiary hearing, both parties to air it all out, have the court listen to it and make rulings. If the court feels that supervised is acceptable at this time, we want their parents to confirm that they know it must be supervised and there's no drinking. We only want to start off with every other weekend, and we want the supervised provision to last 6 months. If we can do it 6 months and everything goes well, then the provision kicks in on trying to go to unsupervised. But number one, suspend full hearing. If we go with supervised, 6 months, only every other weekend. And let's let it go for 6 months to see how it works. Thank you.
Mr. Morgan, is there any suggestion that any of these alleged driving incidents in which he's accused of being under the influence, the child was in the car with him?
No, I will admit that, Your Honor.
All right. Reply argument, Ms. Wheeler?
Well, Your Honor, Your Honor mentioned one of my comments, which was I want to reiterate that none of the allegations that they've made have been supported by any substantial evidence, and they don't involve incidents involving this child. My client has provided the information that he has available to him for the 2 cases that he actually has. It is very hard to prove a negative, but I have continued to indicate to Mr. Morgan there is nothing in the municipal court record, there is nothing in the district court record that indicates that my client was ever charged with the DUI. I can't prove a negative. There's no charge existing. And beyond that, the proposed parenting plan that is essentially what the version Mr. Morgan has submitted with one change to the driver's license language gives my client the obligation to report if there are any new charges related to that kind of violation. It puts him under that obligation. And so we think that the parenting time should be restored as supervised to start. We acknowledge that that would be the best course of action, not limited in time. He deserves to have whatever time he can that was previously agreed to, and to lift the supervision upon completion of that final requirement for the alcohol evaluation. My
So-
apologies, I needed to cough, Your Honor.
Sure, I understand,
but-
counsel. I trust your suggestion is that this court adopt, at least as an existing order, the Exhibit C of Mr. Morgan's packet with a change to paragraph 9 regarding the exchange and who would provide the transport.
Yes, the only change would be that a licensed driver insured vehicle, as opposed to the more specific language that the parent must have a valid license. I think it needs to be broader language than that.
Mhm.
We would like, if the court is considering that, to have it go at least 6 months, see if it works, and only start with every other weekend.
How far apart do these 2 parties live?
Not very, Your Honor. I don't believe. They exchange at a quick trip that's roughly equidistant between their homes in the East Wichita area.
Yeah, I'd say 2 or 3 miles.
Yeah, I think.
Okay, which quick trip is it?
I believe it's 127th Street, located at 21st and 127th Street.
That is correct.
Okay. This 3-year-old is in some sort of daily
Yes, he's in preschool.
daycare program, educational daycare program at the current time?
He is in preschool at Prairie Creek. Goes every day except Friday.
Hmm.
Win-win.
From 8:35 a.m. until 12:30, and then he goes to his daycare.
8:30 to 12:30 every day, then to daycare.
Your Honor, in light of that information, may I make a comment?
You may.
With the daycare schedule, or excuse me, the preschool schedule being 8:30 to 12:30 Monday through Thursday, my client is willing to be flexible with the overnight parenting time he has on. He's supposed to have Wednesday overnight to Thursday, but he is willing to do Thursday overnight instead of Wednesday overnight on. I mean, that would alleviate the concern with the school schedule, I think, but he is willing to offer some flexibility there with shifting that day over. But does not want to give up his time. And if the school schedule is, the school routine schedule is the issue, then I think that can be resolved by shifting it one day as opposed to taking it away altogether.
As I understand the second week, he would then have the child for his parenting time Thursday overnight, Friday overnight, Saturday overnight, correct?
Correct.
Yes, Your Honor.
No school on Friday.
Mhm.
And I think with Thursday overnight and possibly Friday overnight on the alternate weeks. But he's willing to be flexible with that additional Friday overnight to replace the Wednesday overnight of the second week. But at a guaranteed Thursday overnight and then the following week, Thursday, Friday, Saturday overnight.
Court recognizes the constitutional right of each parent to parent this child. Mr. Dester, if there was evidence before this court that you drove drunk with your child in the car, that would indicate to this court that drinking is more important to you than what your child is. That should never, ever happen. And there's no evidence before this court that it has. If you have a chronic alcohol abuse problem, you better do something about it before a critical mistake is made affecting you or someone else. All right. But with that said, the parties apparently have worked together over a period of time to try to balance the interests of each parent and obviously considering the best interest of this child, which has been memorialized by a proposed final order on custody, parenting time, and child support. This court does agree that that the school program, the preschool program that this child has, should not be arbitrarily disrupted by changing parents at midweek. Therefore, the court will change paragraph 6 so that the father would have parenting time with the minor child from Thursday at 5:00 p.m. to what appears to be Friday at 5:00 p.m. And then in the second week, he would have parenting time from Thursday at 5:00 p.m. to Sunday at 5:00 p.m., with the court emphasizing the next sentence. Father's parenting time shall be at his parents' home with them present. Mr. Dester, the comfort level of the mother with you having extended parenting time apparently is currently based on the fact that there is a watchful eye from grandparents. Virtually every grandparent I know bend over backwards for the welfare of their grandkids. And I'm going to presume your parents do the same thing. And they're not going to let you come around or take this child after you've been drinking. And I think that is what creates the comfort level of the mother for this situation. So the court will alter paragraph 6.
November 8th. Yeah.
Paragraph 7 apparently sets forth a plan to be followed as to how you get supervision taken away. Mr. Dester, that is the exception, not the rule. You need to work toward what is more normalized for a father to have. But this is just a 3-year-old child. He probably can report some things that go on, but he's hardly in a position to be able to articulate that dad was drunk all weekend. And the other provisions appear to be sound and in the best interest of the minor child in this case. Now, what you've asked for here, Mr. Morgan, is a 6-month period for supervised visitation. And I'm going to look and see how was that handled in this document.
Well,
how long was it contemplated this would last?
There really was not a time period. It's just whenever he reached a point, he could submit information. So, and that was back in the back. We just feel that that is a reasonable time to let this work and see if it works before he would have the opportunity to submit information and request unsupervised time. Things have changed in that regard. So in the old order, there was not a time frame.
Ms. Wheeler, you've already expressed, I think, some argument and opinion regarding the 6-month period for this. I suppose one benefit to your client would be it would have an expiration date. But you believe it's arbitrarily too long, Ms. Wheeler?
Yes, I believe that we did contemplate a time frame without a specific end date as being set forth by the terms of paragraph 7. And that are the A through E, conditions that father has to meet. And those conditions continue as far as the duty to notify if something else comes up, but the supervision requirement mother would lift that absent additional concerns if father has reported the status of the two cases that we knew about, and we now have essentially final status on both of them. So the municipal court case and the Oklahoma case, he has provided the therapist letter and would continue to do so on a periodic basis. No new charges. They keep her notified, and father does not take alcohol or illicit drugs during his parenting time. What they're suggesting is basically 6 months and these things. What I'm suggesting is these things contemplated a time frame. His final report date for his next report date for the municipal court case is December 1st, and we think that would be a reasonable time to, if there are no issues and he's complied with the final requirement of the municipal court case, he satisfied these conditions, and we would want supervision lifted at that time, absent extraordinary intervening circumstances from today to that point. So December 1st, if he complies.
All right, I'm looking at paragraphs C, or essentially section C of paragraph 7. A letter from the father's therapist that he is continuing to attend counseling and is attempting to improve. Doesn't that necessarily contemplate that there's going to be a period of time in which he's going to work with his therapist?
He's been working with the therapist, Your Honor. We've provided 2 letters, one dated from the end of May and one dated from the end of October. So he's continued to do the steps he can to comply with all of these provisions since we originally started talking about this proposed order.
All right. You acknowledge that, Mr. Morgan?
Yeah, I think we got the letter today or yesterday.
Mr. Morgan received the updated letter today. There was one
Yeah.
that was previously provided back in May.
The court's being asked to consider an end date for the period of supervision in this case. The court has heard from both parties and will establish one. For the rest of 2025, this supervised visitation will be in place. Absent something new, something that violates essentially the spirit and the terms of paragraph 7, at that point, the supervision will no longer be required. But Mr. Dester, again, I hope you've heard the court's admonition and essentially warning about drinking around this child. I wonder if you can go 3 or 4 days in a row, based on some suggestions that are made here, without drinking. And that's the period you're supposed to be taking care of your little one. Your little one deserves you to be at your very best when he's with you. Can you do that? Can you commit to this court?
Yes, Your Honor, absolutely.
I've been promised many things many times, Mr. Dester, and I know how powerful an alcohol problem can be in the life of someone who has such an issue. But if you can get that under control, you should have the normal rights of a father in this case. But we're going to take a restrictive approach for a little over 2 months. Hopefully everything will go flawlessly well, and that you'll be in a position to be able to have non-supervised visitation starting with the year 2026. So that paragraph 7 should be amended accordingly. All right, Mr. Morgan, is there anything else that needs to come before the court at this time to address issues currently before it?
Nope, I think that does it. Thank you, Your Honor.
Furthermore, I trust that there is an ongoing therapeutic relationship going on between Mr. Dester and his therapist. Is that correct?
Yes, Your Honor.
Then I'm going to want a third letter from this therapist in the second half of December of 2025. The court is also interested to see that Mr. Dester follows through on his commitment for this ongoing therapy, and that he is continuing to attend and attempting to improve.
Thank you, Your Honor.
All right. Ms. Wheeler, anything further the court needs to address currently?
No, Your Honor. Thank you.
Okay.
I,
Folks, what we're really interested in here is this little guy and that everything go well for this child. So I encourage the parents, either with each other or through their attorneys, to continue to work together for the best interest of this little one.
I'll do the
Mr.
order.
Morgan, did I interrupt? Did you have something else to address? the
No, I
board?
said I'll do the changes to the order.
Thank you, Mr. Morgan. Greatly appreciated. I'll look forward to receiving that soon in the court signature queue.
All right.
All right. If there's nothing further at this time, the Dester and Martin matter will be in recess.